In this video, I'm going to be talking about how to settle a restraining order. So this is where the petitioner, the person who requested the restraining order, and the respondent come to some sort of agreement where instead of going in front of the judge and having the judge decide their fates, they instead negotiate ahead of time. But if there's a restraining order in place, you need to be very careful with this, especially as the respondent, because you cannot talk to the petitioner, even through a third party, with one important exception I will get to in this video. Even if they contact you first and reach out about settlement, it's considered a violation of the restraining order, and it can actually be used as evidence against you as to why the petitioner should get a restraining order for up to 5 years in the state of California. So you want to be very careful with this. My name is Veronica. I'm a restraining order defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to have your best chance at winning your restraining order hearing, especially if you know that you are not going to be able to have an attorney there. You can win your restraining order hearing while representing yourself, but you have to have the tools. You have to know what to do. And in the course, that is exactly what I teach you. So if that is something you're interested in, you can get your free first class via the link down below. Okay, so let's jump right in. All right, as I mentioned, you cannot contact the other party. If you are the respondent, the TRO, the temporary restraining order was granted, the respondent cannot contact the petitioner, even through a third party. So not through the petitioner's mom or best friend or anybody. You cannot do it, even if the petitioner reaches out to you first, except for through an attorney. And I know that that may be not what you want to hear, and it is unfortunate because attorneys cost money, right? Attorneys are expensive. And actually, some courts will have a mediator on the day of your restraining order hearing that is there that may try to settle the case. So you can talk through that person too. You don't have to pay them, although you won't know until the day of your restraining order. Most people would rather know this in advance, take care of it in advance, and spend the time to make sure that all of the terms that they want in there are negotiated. Now, you may be thinking, well, what is there to negotiate? I want them to drop the restraining order. I mean, they can just drop it, right? And petitioners do oftentimes have changes of heart where they do want to drop the restraining order. If they're willing to just drop the whole thing in exchange for nothing, then great. You won't have to watch any more of these videos. You won't have to go through an attorney. You won't have to present your evidence. So, I mean, that's awesome. But the whole point of the attorney reaching out to them to try to settle is to increase the chances that they will drop the restraining order. You may also be thinking, I'm the petitioner. I want a restraining order. What is there to negotiate? Why would I drop it? And that is a very good question. Now, especially for domestic violence restraining orders, many times there are a lot of issues between you outside of the two of you contacting one another. Maybe you lived together. Maybe you have one another's property. Maybe you have children together. Maybe one of you owes the other money. And usually, even if the restraining order is granted, it's not necessarily going to take care of all of these issues. I mean, for example, what happens if the two of you were living together, you're splitting rent on a place, now there's a restraining order in place, so the respondent is kicked out, the petitioner's still living there, but maybe can't afford the rent on her own or his own. What is the plan there? I mean, this is something that has to be worked out. But an attorney can talk to both of you and draft a settlement agreement that deals with all of these issues. If the petitioner is adamant that they want and they need a restraining order, they need the other party to not be able to contact them, they need them to not come near them, what potentially can be done, and it depends on the court and the court has to approve it, is pushing off the restraining order hearing for a period of time so that a temporary restraining order will remain in place. And then as long as there's no contact during that time, then the restraining order would be dismissed. Now, the advantage here for the respondent is that this means that you then are going to avoid having a restraining order on your record. And, a lot of petitioners, they want to be left alone. Maybe they want control of the property or certain things regarding custody. But especially if the two of you do have children together, the petitioner might not want the respondent to now have a restraining order on his or her record for up to 5 years. It can cause you to potentially lose your job. It can cause you to have problems finding housing. So as the petitioner, if you are in that situation, you do have children together, maybe the two of you are married and you are hoping to get alimony payments in the future, well, how are you going to get those, and child support too, if the other side cannot work, right? So this is a way to avoid all of that. deal with all of the issues between you and settle them so that the two of you can just go on with your lives. Many times when petitioners are filing restraining orders, it's because something just happened and then time passes. And so both people sort of cool down, hopefully. This doesn't happen with everyone, obviously. And so you may not feel the need as much for a restraining order, and you also have all these other issues that you want addressed. And I mean, an advantage to an attorney helping you with this, other than this is really the only way legally to go about settling a restraining order, is that the attorney can make sure that everything is legally binding and have the judge sign off on it if the judge needs to sign off on it, and make sure that nothing goes wrong and that this agreement doesn't end up potentially one-sided. And that this agreement really is the end of these disputes. I hope you found this video helpful, and look, if you are considering representing yourself at a restraining order hearing, you can keep browsing YouTube, binge watching, hoping to find the answers, or you can get all the answers delivered to you on a silver platter, which is exactly what I do in the course. It's difficult to know what you don't know when you are starting something new, and you don't want to miss anything. So the course helps to make sure that that does not happen. You literally have nothing to lose. Go get your free first class. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell.